law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program's been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to help yourself, your family, and your business. We provide information and resources that'll help you determine whether or not you might want to handle some issues yourself. If you do decide to contact outside counsel, you'll be better prepared, and so will they. Hopefully, it will help you save time, money, and achieve a better outcome. We want to once again welcome and thank from the Bazar law firm those who have been helping us with the various topics that we will tackle. David Bazar today.
Dave.
Jackie isn't with us
Great.
today. And we also want to welcome our special guest. His name is Ed Nyes, and he is with the founder of Nyes Law Associates, also based in East Providence. Welcome.
Thank you very much.
So let's start with, for today's topic, the big heading is premises liability, but the specific topic that we're going to use as a springboard is dog bites. Who's responsible, who's negligent, when, and under what circumstances? Seems like it's a pretty straightforward topic. However, there are many different issues that make it a fairly complex and sometimes amusing, sometimes not so amusing topic. Also, because we have a specialist here today, to the extent that there is such a thing as a specialist in your industry, one who handles some of those kinds of cases that deal with restaurants and work areas. We want to make sure that we have an opportunity today to deal with the pros and the cons. So to have David and Ed here, we're going to do a little back and forth. But let's start with the dog bite issue first. So I understand that there are basic issues that you're supposed to be taking care of your dog if you have one, regardless of the breed. And of course, we know that there are some states that have been saying we want to ban certain breeds. That doesn't fly. Most people can still hang on to that pit bull or their Rottweiler, hopefully with a tight leash. So how do you broadly define an owner's liability and an owner's responsibility, and what is a dog bite statute anyway? It varies everywhere.
Of course it does. And Ed and I actually sort of practice on the opposite sides of these cases for the most part. I represent plaintiffs, people who have been injured. By somebody's dog or some other type of injury. Ed usually defends people whose dog has injured somebody, or as you were saying, people who own businesses and someone's been injured at their establishment. So in Rhode Island, for example, we do have a statute that says that if your dog is outside of the enclosure, meaning the property, and then Ed and I can talk a little bit about what that actually means, and the dog attacks somebody and injures that person, you're strictly liable for those damages. And we can talk a little bit about what strict liability means. From the plaintiff's perspective, it means you have to pay our damages. I know Ed has some other thoughts on that. But let's talk about that a little bit, Ed. The enclosure in Rhode Island, what do you think that definition of that really is under case law today?
Well, that's been an evolving topic. It's been up to the Supreme Court several times. And there was actually a recent case where a UPS driver entered a person's property, I believe was aware that there was a dog on the premises, and he was bitten or attacked in the driveway. And under the statute, now that you would think that that would be an enclosure because it's on the dog owner's property. However, the Supreme Court said because it was not actually separate, secluded, fenced-in area, it was a driveway, there was
a question
of fact as to whether this was actually an enclosure.
Ed, does that pertain to Rhode Island and Mass? Is it different? If it's in the Supreme Court, how does it differ from one state to the next?
Well, I'm only familiar with the Rhode Island law on this topic, actually.
Yeah. And state to state, there are wide differences between how they
Because typically, until this recent case, where actually the trial justice granted summary judgment in favor of the dog owner because he said the bite occurred on the person's property. And it went up to the Supreme Court, and the Supreme Court said, well, it was a driveway, it really wasn't a fenced-in area, so it's a question of fact, we're going to send that back for decision. And up until that time, typically it was understood that if the dog bite, and it doesn't necessarily have to be a bite. It could be a scratch. The dog can jump on you. It's injury caused by any animal. And it doesn't also necessarily, it's not restricted to dogs. It applies to all animals.
Cat
horses,
or your pet snake.
Horses,
Poisonous lizard.
sheep, cattle, whatever it might be. If an animal injures you, and it could be the animal jumps on you and you fall down and break your hip. It doesn't necessarily have to be a bite, but if that happened on your property and was the first time that the animal had ever attacked the person, then the homeowner would be
not liable.
Exactly.
What does the dog statute mean? What is the one bite? It's kind of misleading. As I was reading about it, there are nuances that make it very difficult to understand from state to state, that is. Can you
Right, and every state statute is
Mm-hmm.
different, and there's nuances, as you say, to each one. As Ed was saying, the ones we've dealt with, primarily the Rhode Island statute, it's similar to other states, but as it's applied can be different. But the one free bite, as you say, what does that mean? If it's on the property, and that's what Ed was just talking about, the enclosure, then there's no liability if this dog has never done anything like that before, or animal, and it's unexpected and it's just something that happens for the first time, there's a free pass. But if it happened off of the property, then it's not a free bite at the apple. There is liability, or there can be liability.
Even if the dog's on a leash.
Right.
If it's outside that dog's enclosure, the owner's property, which is now becoming
an issue.
Then there's automatic liability.
Yeah, and talk about that strict liability. How does the court apply that? What do we mean by that? What do we have to prove as a plaintiff, and what do you have to defend as a defendant?
As a plaintiff, you show that there was a bite or an attack or an injury caused by an animal outside that animal's owner's property, then that injured person is automatically entitled to be compensated for the damages, medical expenses, and whatnot.
So I have a question about that. Suppose it was a child, for example, and a child might be friendly or maybe a little too friendly and not quite understand how he or she should behave toward a dog, or maybe it was an adult and maybe the adult taunted them. Doesn't matter, or does it matter? If you happen to be the victim. Okay. How about first on the owner's property? How about then on the street? Would it be different?
Well, if it's on the owner's property and it's the first time, I don't believe there would be any different. But if it's the second time and they can establish that this dog has a vicious propensity, then liability would attach. Now, if you have a situation where somebody's provoking a dog, you could raise that as a defense.
Right. That's absolutely correct. And you can have contributory negligence defenses in strict liability cases under the Fisk versus McGregor, or whatever that was, the helmet case.
The hockey injury.
Football. Where the football helmet injured the guy, paralyzed him. But the real issue that you're raising is some creative thinking, which is, as a plaintiff's lawyer, what I like to do. So I had a case once where this woman agreed to babysit my client's child, and therefore my client, and also her neighbor's pit bull at the same time. And it was the first time, allegedly, that this dog attacked and injured somebody. And my argument to the judge was, well, I'm not suing her because of the dog bite. I'm suing her for negligence in how she cared for and supervised the child. And my argument was that if she had an open window, that's not necessarily negligence, but if you allow the child to play near the open window, now you're negligent. So I wasn't using the dog as the instrumentality of the negligence, so that was going to be my argument. It settled before it went to the Supreme Court. Be curious as to what you think a court might do with that kind of argument.
I think that's a creative argument that would hold water.
Yeah, don't you think it should?
I think it should. You'd mentioned children. Children under a certain age cannot be held comparatively negligent. They have to be old enough to have the intelligence and I can't remember the exact definition, but there is a certain cutoff where a child just could not be held.
Right.
comparatively
And it
negligent.
goes back to the whole notion of negligence, that it's a reasonably prudent person giving the age, experience, education, so forth.
That's
so
it.
when you have the age of a child as part of the consideration, well, what's a reasonably prudent thing for an 18-month-old child to do?
And keeping with this topic for just a second, while we know that there isn't a ban on Rotties, on American Standard, the pit bulls, but are you supposed to assume that those breeds of dogs are likely to be attacking or to be more aggressive, and therefore, as an owner, you have to take additional, is the onus on you as an owner to be more responsible, have a tighter leash, or walk them with a muzzle so that you don't become sued if something happens? Do you have more responsibility because of the name of the kind of dog that is?
No, I know there's a perception out there in the public that Rottweilers and pit bulls are the types of dogs. They're the ones we see in the news and hear about, you know, their propensity. But then that creates a whole debate among owners and lovers of those breeds of dogs who say it's not the dog, it's the way that they're raised.
And I can tell you the Supreme Court, people have tried that approach with the Supreme Court, and the Supreme Court of Rhode Island has said we do not have breed-specific negligence. It doesn't change from breed to breed. It's the same application of the law, no matter what type of dog it is.
Eliminate prejudice.
Right.
On that topic, I do believe that there are some insurance companies who will not provide you with homeowners insurance if you have one of those breeds, or there may be a extra premium on top if you do have a pit bull.
And they do that. However, as I said, the Supreme Court has rejected that, and they've also rejected the argument that if the town has an ordinance banning the dog, pit bull, for example, and you try to raise that as, you know, negligence per se, that type of thing we talked about where it's a violation of the law is proof of the negligence, that's been rejected too.
Good to know. It seems that if someone is nipped at, go get stitches, why does it have to become a legal case?
Well, from a plaintiff's perspective, I had that case I told you where the child got nipped at and had 52 stitches in his head.
That's more than a nip.
Well, I mean, but so it's the level of damages is what you're saying. And if you're saying that it's so minor that it doesn't warrant a claim being made, that's possible. And most attorneys will evaluate a case both on the negligence and the liability and on the amount of damages, because, as you say, you're not going to bring a medical malpractice claim against a doctor if he left an extra mark when he removed a wart or something. They're expensive cases. All legal issues that are brought to court can become expensive. So most lawyers are going to weigh and balance what the return would be versus what it will cost to bring the case to trial.
And also it's personal preference. Someone may get bit by a dog but not be of a litigious nature and just not want to bring a suit. I got bit, I'll take care of it. I'm not going to sue that person. It's my uncle's dog, for example. Or people get rear-ended in car accidents and get hurt and just don't believe that it's right to bring lawsuits. Other people are very litigious. So if they got a scratch, they might go run to the emergency room and run to a lawyer and file suit because that's their nature. So individual choices.
Right. And when we're picking juries, he's going to keep that person on who got rear-ended and doesn't want to sue anyone, and I'm going to want them off, and I'm going to take that person who said, hey, you hurt me, you owe me.
Good to know. And before we segue into what happens at a business, let's talk about the dog issue with a business. So if a business has a protective dog, maybe they have cars or whatever, I'm not sure what example I would want to use. How does that change, or how does that impact?
Actually,
deeper
it
pocket.
doesn't have to necessarily be a business. It could be a landlord. And I wanted to add that the statute not only applies to the owner of the dog, but the statute also applies to anyone who keeps or harbors that dog.
Define harbor or clarify, please.
A harborer. So, say this dog, a little bulldog, belongs to someone's fiancé, and that fiancé moves in with her soon-to-be husband and brings the dog with her, and that dog bites somebody outside that property. Now, the fiancé is technically the owner of that dog, but her soon-to-be husband, it's living in his premises now, so he's actually a keeper and harborer of that dog, so liability could attach to him as the harborer and keeper.
Right, and on that case I had where the babysitter was watching both my client and the dog, and the dog had been staying with her for some time. The argument was she's harboring the dog in her premises because she was keeping the dog there. So if the dog is going to be there for some length of time, I think you could argue that you're a keeper or harborer of the dog, not necessarily the owner.
That's something people should know if they end up babysitting or pet sitting or whatever.
Right.
And landlords need to be aware of that too, because if a landlord knows that there's a dog in one of its tenants' properties.
Yeah, they can be responsible as the owner of the land.
Okay, let's make that segue then to things that happen with premises liability as it pertains to, say, at a store. The slips and falls that we've addressed before, those are called torts, correct?
Yeah, any civil wrong is called a tort. So if I injure you in some way and you sue me civilly, you're suing me for a tort, whether it's the tort of negligence or an intentional tort, as we talked about before. But yes, a tort is a civil wrong that you can be sued for damages.
And someone is reaching for something at the top shelf of a grocery store, and there's a catastrophe. What happens? Who's defending and who's on the other side today?
He's
I'm
defending.
You're going to
defending that
defend.
case.
Go ahead.
So start with Ed.
Saying that that person should have gone to a store clerk and asked for help if they couldn't reach that item.
And I'm going to say that they should not have merchandised the item in the way they did, so it's so high up, and they're tempting my client to retrieve it.
You're 3'2", and the shelf is 6 feet. You're 6 feet, Ed. You might not have a problem, but the 3'2" person does. Do they have a leg to stand on if they fell?
Well, two in that case, but...
Well, from my perspective, that person has no business climbing the shelf or reaching something that's clearly beyond their reach and could create a danger to themselves. So I'm arguing that that person is completely responsible for their own accident, fully comparatively negligent, no liability on the store. They could have gone to get some help.
And I'm arguing that the store shouldn't have left that ladder in the aisleway, so my client went and took the ladder and tried to climb up it and fell.
Hopefully the store does not leave the ladder in the aisleway.
How about the big box stores that have large and cumbersome items, and they put the fence up, but someone is impatient, doesn't want to wait for the sales clerk to come by and figures, I'm strong, I can take care of this, and they do, and oops, now what happens?
Again, I'd take the same position that that person was responsible for.
I'm not really on your side, but I am setting it up that way, I guess.
You're doing a nice job, and I'm always going to find a way
David,
in.
Go ahead.
So give me your scenario again.
Well, you're at a big box store and there's a large item and it has a fence in front of it because they sort of expect that you will hail a salesperson, a knowledgeable professional salesperson who knows how to operate equipment and forklifts, but you just got a little bit impatient because no one was coming and it is Saturday and you have other things to do, and long story short, you end up fetching, and it wasn't that heavy, you thought, but for whatever reason, you pluck it and it falls on you and you have some sort of minor or major catastrophe.
So I don't know what the fence is because I've never seen anything fenced off in a store.
Those yellow gates that are accordion-like that say, don't trespass, but people do anyway.
But
Some do.
But it didn't say that in this case because all you said was that there was a fence there, so
Yes.
my client didn't know why that was there other than that the item they wanted was there, and it was not Benny's because nobody was coming to help them to get their product, so they waited and tried and couldn't find anyone, so the store didn't provide the assistance they should have, so my client got injured.
Point, counterpoint's very interesting here. Ed, of the kinds of cases that you are defending like this, you're trying to take care of the store, what kinds of cases are the most difficult for you, most challenging for you to represent?
Well, Let's
If you can give us an example,
take a
maybe.
supermarket, for example, as I've defended supermarkets for more than 25 years.
Okay.
What we like to see from the defense point is a complete, thorough investigation of what actually occurred, the accident. Now, clearly the most important thing for the store or property owner to do, because they have the duty to exercise reasonable care. The first thing, if someone gets injured, the priority is to take care of that injured person, to get the medical help, call 911, whatever may be necessary. But there needs to be an investigation of that accident. What time was it? Were there any witnesses? Were there any store employees in the area? Get their names, get their phone numbers, their addresses. What did that person fall on? When was the last time that area was swept, inspected, or cleaned? Because there is an obligation for a person who falls in a store to prove that the store knew that there was a danger on the floor, or that they should have known by the exercise of reasonable care. And the way that people meet that second burden, which is more challenging to show that the store should have known, is that there's got to be some indicia of notice that the typical example is a popsicle. If somebody comes and slips on a frozen popsicle, who knows how long that was there? A child could have just dropped it out of a carriage. But if that popsicle's frozen and it's a stick and a gooey substance around that stick, that gives you some idea that that popsicle's been there for a sufficient period of time to have given it a chance to melt. And that would create a problem for a store, because then there would be an argument that the store should have known that that melted popsicle was there.
Is it difficult after the fact, which is when you're called, obviously the person's been tended to, they've been to hospitals, doctors, or whatever, and then you're involved with the store and representing them. Is it hard for you to go back and retrospectively recreate the scene and find the witnesses and find the testimony and the supportive documentation? Is that a difficult thing at most cases?
It's case-by-case basis, and oftentimes, because we have a 3-year statute of limitations in Rhode Island, when 3 years pass by, it's sometimes hard to get back in touch with those employees and witnesses, and you know, as everybody knows, with time, memories fail. So that's why it's important to do a thorough and accurate investigation at the time. And if a store has, if it's the routine practice of a store to create accident reports, it's very important to have that accident report. Because if I get a case and this accident was reported and we cannot find a report, but it's that store's routine procedure to maintain and keep reports, that presents a problem to me, because the Supreme Court has issued a decision which says that if it's the procedure of a store to maintain accident reports and one cannot be produced, then a judge is allowed to instruct a jury that it may draw a negative inference from the fact that a store was unable to produce a report.
Good to know. And David?
From my perspective, my client's going into the store, they fell on something. In the old days, pre-cell phones, they could get names of people. If they're with someone, they could obtain information and get as much as they could while they're there. But today, I would hope that someone, if they're with someone or if they're not in too much pain or difficulty, that they might take a picture of what it is that they fell on to show that there was something there that caused the injury that could have been picked up or repaired or maintained by the store. So that's part of that. And I was going to comment until Ed did that. And then when it comes to me, which is sometimes much later, I want to see that report too, which I won't get. Sometimes you could claim work product or something, but if it doesn't exist, they have to at least identify it. If it doesn't exist, it's spoliation. That's what Ed's referring to. That's what we would argue, that there's some evidence that they don't have, and therefore they must be covering something up.
And you know, in our mission in general here, Ed, we try to share information and educate people, and often it's from David's perspective on who's defending the victim. And in your case now, would you say prophylactically that you would advise businesses that you represent before there's a lawsuit, do they need to have a better sense of policies, procedures, so that the minute somebody nicks themselves or slips and falls, they better have a policy in place or a report?
It's important to have safety procedures, and routine cleanings and industry standards these days are that stores should inspect and clean their floors at least every hour. Stores are getting better at implementing procedures to keep the stores safe and clean, and with technology advancements, particularly surveillance and the advancement of technology, there's going to be a point in time down the road, I see, where most accidents are going to get caught on camera, and it will be the obligation of that business owner to preserve that tape of that accident, because if they fail to do so, then David is going to raise the issue of spoliation.
And it's interesting that Ed's talking about cameras. I had a case once where a woman was injured after she checked out of a store. It was a office supply kind of store. She turned to leave and she hit some box. There were 2 boxes of papers, reams of paper that were piled up because they were on sale, but they were below eye level. There was only 2. The display at the next checkout point was like 4 high with the sign on top, "This is on sale." So her argument to me was, I never saw it, I turned to leave, I tripped over it and fell. So they did have the tape, and we got the tape, and it was not a great tape, but when you looked at it, the store's argument was she didn't really trip over that. It was too high for a trip over, but if you looked at it closely, her foot hit it as she turned and she fell. So it was good evidence really for us.
Would it matter if the person happened to be a little bit older, perhaps disabled, a little bit infirm, or would that not matter at all?
Well, it depends on the situation. In that case, it wouldn't have mattered because no matter who you were, you couldn't see the display as they had it laid out.
It's interesting that David mentioned that particular case, because before we were in the same office together, I was actually chosen to be the arbitrator to resolve that dispute.
I remember that, yeah.
Because I do handle plaintiff cases as well as defense cases, and I frequently get chosen to serve as arbitrator to decide civil disputes because people perceive that I'm fair, and I like to think that I am.
That matters.
So I do that quite frequently. I was chosen as the arbitrator in that case, and based upon that surveillance evidence, it was that paper was clearly stacked in an area where no one would expect paper to be stacked, and so there was a finding against the property owner in that case.
Thank you. Quick comment. Is it possible even for small businesses to be able to put in cameras these days? Do you suggest that they do that even if they don't have the HR policy, if they're not chain stores or big box stores, at least for their own protection so that they have some defense in case these things happen?
Yes.
Yeah.
Important.
Yeah, I mean, it's not that expensive these days, and you should do that.
Good to know. Well, Ed, thank you very much for joining us. David, we really appreciate your tuning in. We hope that we've been helpful to you as we've explored some of the complexities of the premises liability, from dog bites to slips and falls. Stay with us for the next session of Law Matters, because the law matters to you.